Hey, Juanita.
Hello, Mark.
These Wednesdays just tick around so quickly, except today's Thursday.
It's a delayed live stream today, Thursday.
It's a delayed telecast. Anyway, great to see you again. Getting lots of good feedback about the things we've been talking about in our estate and succession mastery session. So, thank you for being the smart one in the group. That
full of compliments. Thank you
people
for the feedback, everyone. That's great. Any topics that you want us to talk about, make sure you let us know.
Absolutely. Send us a note if you have any particular questions. Please just shoot us a note, and happy to cover those off.
Yep.
So the topic for today is what assets are inside, outside a will, and why does it matter? And this, once again, is one of those things that if you don't get proper advice when you're doing your estate and succession planning, it can really turn to dust. So, and I know you're busting to talk about this, so
I'm excited about this topic.
You've got all the examples and everything.
Yeah, I think this topic will really blow some people's minds, because a lot of people just have no idea about some of this stuff. And as you alluded to, it can really end up in a disastrous result if the right advice isn't given or obtained. So shall I kick off? So assets, well, let's maybe start at the end also.
Okay.
Why does it matter? Because, as I said, your whole estate plan can just be blown apart by treating these assets incorrectly. That assets that are outside your will or inside your will, or there's my puppet hands again. Yeah. So, and there's some other strategic reasons too why they need to be identified, but it does matter. It matters very much. So the first asset we'll talk about, and when we say assets that are left in your will or in your estate, these are assets that you are able to leave in your will to who you wish. There are some assets that you can't, that sit outside your will or sit outside your estate, and you either can't leave them at all because you don't have the legal ability to do that, or you leave them, or you put your estate planning or leave them via a different document to your will. So there's a couple of different reasons there, but you really need to know the difference. The first one we'll talk about is joint assets. So I'll talk about property and bank accounts, but we might start off with joint property. Interrupt anytime you want, Mark, because you know I love this topic, and I'll just keep talking for half an hour.
Oh, well, I'm not game to interrupt you because you're on a roll. But I mean, what you were talking about was just the very essence of the whole topic, wasn't it? Is that the fact is not everything goes through your estate. So I mean, you can have all the greatest intentions, and you can think you've got this great will documented, and you've gone away and you've done some research and you've written all this stuff in your will, but I mean, if it's not things that pass through your will, kind of pointless. So no, I think this is a great topic, and I'm not game to interrupt you. So far, you just keep rolling on.
The first thing we're going to talk about is jointly owned property. And to give you a property ownership 101, if two people own property together, two or more, you can either own it as joint tenants or tenants in common. And the difference is this. If you own it as joint tenants, which is quite common for married couples or people in a relationship, when one of you dies, the other automatically becomes the owner of that property via survivorship. The property does not pass through your estate and is not left via your will. Even if you have put a gift of it in your will, doesn't matter. So if Mark and I own a property as joint tenants and I die, it's Mark's, full stop, and vice versa. Now, the other way you can own property is...
Can I jump in and ask a question there?
Sure.
I mean, this must turn to dust so many times for people, and especially, with second marriages and so on. So, you and I might own something, you've got children, you actually wanted your share of that property to go to your kids.
Right.
You and I had separated a few months before, whatever, and I don't care for your kids. So when you die, the property comes to me, and I have no intention to give it to your children. I'm not really that bad a person, but I'm just painting the story here. And does people go to court? I mean, does that if someone went to court and said, that really sucks, it was, she wanted to give it to the kids, it's tough, really, isn't it? Just too bad.
Well, there's no way you can go to court to say you don't like that, because that's just the way it is. I mean, we know about contesting wills, and I'll probably touch on that a little bit later as to how that fits into all of this. But if a property is owned as a joint tenants and one dies, that's it. That's the legal position.
There is no argument.
Yeah. Now, the other way you can own the property is tenants in common. And this literally means you own a portion of the house. You could draw a line through the middle of the house. Mark owns that half, I own this half, and I can leave my half in my will. That is the difference. So when I die, it will go to whoever I leave it to in my will, and Mark will still own the other half. So it's quite possible and very easy to change what we call the tenure of ownership, so change from one to the other, from joint tenants to tenants in common, or vice versa. And there are specific reasons or estate planning reasons why you would prefer one over the other. And there is no right or wrong. It's what's best for your situation, taking into account things like blended families, testamentary trust and asset protection, if you're worried about someone contesting your will. You really need to get advice around what is best for you. But for the purposes of today, it's important to know that if you own a property as joint tenants with someone, you cannot leave that property in your will.
And in fact, so you just touched on something which was interesting. So if it was likely that someone was going to contest your will, the best way to own something would be in joint tenancy, so that it wouldn't even go through your will. And if you had a hostile child or something like that, likely to contest a will, if you have it in joint tenancy, it just bypasses and no one can argue about it.
Yeah, that's right. Yeah. And as I said, there may be other reasons why it's preferable as tenants in common, and it's a matter of balancing out the pros and cons. But what you just said is absolutely right, Mark. If you are worried about someone contesting your will, or that asset being exposed to such an action, then that's one way to keep it out of the estate, to hold it as joint tenants. But don't go rushing off and doing that without getting more wholesome advice about the whole situation.
Well, because the whole issue of testamentary trusts and so on, I mean, that's when we're mostly taking assets out of joint tenancy and putting them in tenants in common, so you can direct it through your will and put it in a testamentary trust. But you're probably coming to that, so I'll just shut up.
Yeah, no, that's absolutely right. So that's another that's a very good reason why we might say to a client in their circumstance, irrespective of that joint tenancy possibility, we think you should own it as tenants in common. So when one of you passes away, their half will go into a testamentary trust and will be in an environment where there's great asset protection. So instead of being exposed to potential future relationship property settlements or insolvency issues, if those are sort of risks that a client might be concerned about, then tenancy in common is the way to go. So you can see how there's no one size fits all, but as I said before, for the purposes of today, if you own a property as joint tenants, it sits outside your will, and you can't gift it in your will. And similarly, along that vein, is joint bank accounts. So very, very common for a couple to have a joint bank account in both their names, which they both utilise and access. When one person passes away, the other becomes the sole owner of that bank account. And it's just a matter of the bank updating the bank account details, the internal records. They'll obviously need proof of death to do so. But so practically, if Mark and I have a joint bank account, Mark dies, it just gets updated into my name. So similar practical considerations to what we just discussed with a joint property. Can be useful. Yeah.
Yeah, well, and the kids will be lining up with guns at dawn.
Sometimes we do see that. The next one that we're going to talk about is superannuation. Now, most people don't know this when we speak to them about their estate planning. Only a small minority do. So
I hope I do.
Superannuation sits outside your will. Yep. So superannuation, as a starting point, you don't just leave it in your will. You have to fill out, well, you don't have to. but it's advisable if you want to leave your super to someone in particular, or your estate, which I'll come to. You fill out a totally separate form, which is called the death benefit nomination form. So everyone who's got an industry super fund, you can go online, you could probably Google Sun Super death benefit form, and you can download the forms off the internet, or your solicitor can do that for you, or your financial planner, and help you fill it out, because it looks like a simple form, but the slightest little mistake can really upset some estate planning here and make these forms invalid. So super is left in your binding by your binding death benefit nomination form, or your death benefit nomination form. For those of you with self-managed super funds, usually in the back of your trust deed, there's a template, which is what the nomination form for your trust deed should look like. So you, in those circumstances, you may print out that form and fill it out and nominate who you would like to leave your super to. Having said that, for those of you with self-managed super funds, it's always important to get advice from your financial planner, because there may be reasons why you don't want to do a form and provide a bit more flexibility. But certainly with our industry super funds, we would usually recommend, depending on the individual, but usually recommend a form be done nominating who you wish to leave your super to. Now, you can only leave super to a spouse, a child, or a dependent, or your estate. So on the form, you might fill out your husband or wife's name, your child's name, or your estate. And again, really important to get advice around that, because depending on who you leave it to, there are different tax consequences. So a spouse might not get that amount of super might not get taxed, but if you leave it to an adult child, it would get taxed. So there are some clever little things we can do with your estate planning to minimise tax that you can pay on super. And it also comes down to different components of your super. So before you fill out those forms, get advice from your financial planner and your lawyer around that. Now, for those of you that are, yes, Mark.
May I ask a question? You're going so well. I mean, this just raises a whole point, doesn't it, Juanita, that people are trying to do all this stuff themselves. And I mean, you know, you run across people all the time that, or once every now and again, that people think they can do this themselves, and you know, why would they pay for advice? You know, they'll just go in and do this themselves. There's just so much you need to know, and I mean, it's second nature for for people that are doing this all the time, yourself and others that specialize in this area. It's second nature. But the average Joe just has no chance of understanding all the different intricacies of what can go wrong in an estate or a succession plan, and that's why they need to communicate with. I just had to throw that word in there. That's why they need
13 minutes today, longer than normal.
It's the longest ever. They need to communicate with someone who actually knows what they're talking about. You just can't know all this stuff, can you? I mean, you're just rattling it off, and it's, you know, and I understand because we do this enough together with clients and so on. But I mean, average people couldn't hope to understand this. I mean, they could get the form, they could talk to their superannuation guy, and they could probably speak to half the financial planners too that are out there, and still not get the same level of options and advice and in regard to what you're giving today. So thank you for what you've already done, and I'm looking forward to the rest of this.
Oh, we've got plenty to go. Yeah, this is fun.
I know. I just wanted everyone to know that this was valuable stuff. You know, don't glaze over when you're listening to this.
Yeah.
This can cost a lot of money if you don't do it the right way.
Absolutely, that's a fact. Yeah, and as I just touched on, what you can do is on the form leave your super to your estate, or your legal personal representative is the words that they will normally see. When you do that, then your super will flow into your estate, and you can leave it to certain people in your will. But that's only if the form is filled out in that manner. Otherwise, it'll go directly to who is nominated on the super form. Now, a lot of people will say, well, who should I leave my funds to? To my spouse, to my children, or to my estate? And the answer is it depends. So it depends. I'd be asking you questions such as, what other assets do you want to leave to who? Is your child an adult or a minor? Because there are different tax consequences. Do you have any dependents? Do you have perhaps a child with a special disability or a need? So there's, are you worried about someone contesting your estate? So the answers to all these questions will tell me what the best plan for you is when you answer them. There's no black or white, right or wrong. Probably one question people will ask is, what if I don't have a form filled out for my super? Or what if I fill it out and it's wrong? Well, if you fill it out and it's wrong, it's like having no form. Another thing is they often lapse every 3 years, the industry funds. So if you fill one out, then 3 years, it just automatically lapses if you don't do a new one. So that's the effect of having no form. In that circumstance, what happens is the trustee of your super has the discretion as to who it goes to. As long as it's within that class of spouse, child, dependent, or estate, they get the decision. So that is the law. They have the discretion. So you can obviously see that it may simply go to someone you don't want it to go to. And
absolutely,
yeah, and then follow. People can contest your super as well as separate to your estate. Wow. So that can certainly raise raise some disputes there. Yeah.
A quick question. So and I ask this question because people, marriages do fail. So someone's put down their spouse as their beneficiary, which was good advice at the time, tax-wise, and for all those sorts of reasons, and they separate, but they've forgotten to change their nominated beneficiary form, then they die. How does his estate go with trying to contest, against an ex-partner, for example?
With great difficulty. So yeah, again, if there's a binding form completed to a legal spouse, but they haven't legally divorced and they're still legally married, then yes, they're still eligible and the form's binding. So it can cause all sorts of complications. That's why if you are separating and you go see a family lawyer, one of the things I will always ask you is your estate planning up to date? So very, very important to consider that as part of that whole process.
Yep. Okay. Good point.
Next on our list is life insurance. So life insurance will not necessarily, like super, flow into your estate. So on your life insurance policies, you'll see who owns the life insurance policy and who the beneficiary is. So if you own your own policy, then yes, it will come back into your estate because you own it, and when you die, your estate does. But if you, if someone else owns it, for example, your company, or maybe someone else, your spouse owns it, it will go to them. But you might also have a different nomination of a beneficiary with your life insurance. So no point putting in your will, I leave my life insurance to X, when the policy says something different. So always important as part of our estate planning for us to have a look at the life insurance policy. We check off who owns it, we check off who the beneficiary is, and make sure that it can flow to the person that you want it to go to.
Well, it may not actually be on the policy document itself, Juanita, as you know, just so to clear that up. The best thing is probably to look at the annual statement, isn't it? Because that usually
absolutely. Yeah.
But I mean, there can be situations too where, in the day when you would assign a life insurance policy to a bank while you, as security for loans and so on. So sometimes you might need to dig a bit deeper. Speaking general public here, just because it says something on the policy document, the policy may have been assigned to a bank. You might have done a nomination, a death benefit nomination, a non-superannuation policy, and somebody else might be the beneficiary of the policy, and it's, there's no marks on the policy document if they give them these days, or it may not even be on the renewal statement.
Yeah, that's right. That's right. So it's all about checking the documentation.
Getting good advice.
Read the documents.
And communicate with the right people.
So the next type of asset that doesn't form part of your estate, or you can't leave in your will, is assets that are owned by trust, so trust assets. So for those of you that have a family trust and the trust owns assets, whether it's property or cash or shares, etc., when you die, the trust will continue to exist and the trust will continue to own those assets. So even if I put in my will, I leave the shares in Juanita's family trust to Mark, that gift is invalid because the trust will own those assets. What we can do and what we do is in the will, we can pass control of that trust. So the important bit, and this is an example of the sort of thing that you don't find in your will kit, right? Your post office will kit. What we will do is draft into your will that when I pass away, I want the control of Juanita's trust to go to Mark. Therefore, you will then carry on control of that trust, and the trust will own the assets. And of course, the reason why we have assets in trusts is for asset protection and tax efficiency. And so, that's definitely a great structure that many people have, but it's important to know that you can't leave those assets specifically in your will. It's all about control.
Good point. Yes, as it often is. So the next topic, because I was going to ask a question if you got to the end of.
I've got one more. I've got one more asset.
Then I'll ask the question.
Similarly with trust assets, assets that are owned by companies, you can't leave for the same reason. The company owns those assets, not you. What you can leave in your will is your shares in that company. So for those of you that have a company that runs your business, and the business might own plant and machinery, bank accounts, furniture, etc., you can't leave that stuff in your will. But what you can leave is your shares in company Pty Ltd. And that's really important as part of your succession planning and who you want to be running that business and controlling that business if you pass away. So just another reason why your will needs to be specifically drafted and carefully drafted to pass on the right asset, being the shares, and not the furniture and the bank accounts and the investments that the company owns.
So, Juanita, how many times does it happen? Because you work both sides of the estate planning minefield, don't you? You go into disputes and so on at the other end as well. There'd be a lot of people that would just merrily go through life, and their accountant said, "Oh, we'll buy this asset, and the company will put this asset in the trust, and this one we'll put in your wife's name, and this one we'll put here and there." And so you end up, and you just in your mind just thinking, "Okay, well, I own all this stuff." Even though legally it's in different entities. So how often does it happen that somebody passes away and they sort of just assumed that all this stuff was theirs and they could direct it in the manner they wanted to? They had some art which they thought they'd give to their their daughter and some jewelry or whatever, but actually the company owned that, so they didn't have the right to hand on. How often does that happen that there's a dispute afterwards because the person writing the will wasn't actually able to divest those assets in accordance with what their wishes were?
Yeah, every day. Every day. Every day there's a dispute.
That's why we're doing this.
Yeah, up in the Supreme Court just behind me here, every day there's a dispute about this type of thing, what's in and what's out, and people being left out of wills and whatnot, or wills being drafted such that they're confusing and they're not clear, and the court needs to give some direction on what the construction of the will should actually be. But another one that, as you were talking, Mark, that I haven't mentioned, but it's quite probably pertinent to our rural listeners, particularly, are partnerships. So a lot of our rural businesses will be run in partnership scenarios, and really important for clarity around what is a partnership asset and what isn't. So it's not unusual for us to see partnerships where there's no partnership deed or agreement.
That happens every day, doesn't it?
Cool. Yep. And assets, financial statements might be prepared for tax reasons, or assets might appear in them or not appear, and what people think or intended is different. Really important to get clarity around what assets are belonging to the partnership and partnership assets, and what assets are owned by the individuals. I've recently been in an estate dispute where that was the key issue. At the end of the day, what properties were partnership assets and what weren't, and the whole distribution of the estate revolved around that key issue. And it was a historical partnership where there'd been a lack of clarity on that particular point.
Yeah, look, I'm just going to, and I know you're short of time today, so we'll wind up soon. Today's just been so valuable, Juanita. Thank you, because all these sorts of things are they just lead to grief and aggravation and family disputes where siblings don't talk to each other, cousins will never get to see each other again because of, the siblings are blueing, and it's just such a tragedy. And look, I'm going to call this out. I've got someone we're dealing with at the moment is starting to dispute. Why are we going to a lawyer who's going to charge us this much when our local guy says that he can do all our estate and succession planning for $1,200? And I just shake my head and I think, how can you go through this minefield? And this is a complicated family, 4 kids, assets all over the place, and it's just like, how can a solicitor stand up there and say we can do this on the cheap for $1,200 when there's just so many things you need to take into account. And from what you've gone through today, this is just simple stuff that we're talking about today: superannuation and ownership of assets and structuring and so on. I mean, this is just the pointy edge of the whole planning process. You might save a few dollars at one end, but I mean, at the other end, and I always tell people, you're probably going to start at a $200,000 legal bill and work your way up from there if there is a dispute after somebody dies. And that's why, I think it's the brain surgery analogy. If you've got a tumor, you don't go to a GP, you go to a specialist. I love working with Juanita, you guys, Tom at Murdoch's and so on, because you just eat, sleep and breathe this stuff, and you know what to look for. And I think when you're doing anything in regard to estate succession planning, you need to go to someone who absolutely knows what they're talking for. And I really appreciate what you've gone through today, Juanita. It's been really, really useful. Thank you. And the listeners, I hope you've got some great value out of this. And if you want a second opinion on what you've got in place at the moment, can't recommend these guys highly enough. Just go in, tell them you've come from Estate and Succession Mastery podcast, and you're after the second opinion. And I know you guys will throw your eyes over it and see if there's any landmines that are obvious.
Absolutely. Okay. Yeah. I hope listeners have got some value. There was lots there, and hopefully you learned something new, because it can be so important and really make a huge difference in your estate plan and save you a lot of money.
Yeah. It's the money at the other end that's the expensive. Yeah. The money at this end, getting it done, is nothing compared to the money at the other end when it all turns to dust. So
yeah, absolutely. Yeah.
Hey, thanks for your time today. Going to give you a break 2 minutes early. So thanks for everything today, Juanita. Love listening to you again as normal, full of wealth and knowledge. Thanks.
Thanks,
Next
Mark.
fortnight. See you then.
See you next time.
Bye.